Good evening, everyone. So, I'm here to continue about the correctional institution about Bucor. So, section 19. So, standardization of the base pay and other benefits of the uniformed personnel of the Bucor. So, in order to enhance the general welfare, commitment to service and professionalism, the following are considered uniformed personnel of the Bucor. So, next slide. So, this tells the ranking ranking of the Bucor and their duties inside the institution. So, next slide. So, the DBM shall determine the equivalent rank of the uniformed personnel of the Bucor patterned after the existing ranks of the military and uniformed personnel of the other departments. So, the base pay, allowance, and the other benefits of the above mentioned personnel shall be in accordance with the existing com- compensation and position classification laws and regulations. So, the base pay of the officer or the personnel in the Bucor is is it depends the rank or their duties inside the institution. So, next slide. So, next is section 20. So, retirement benefits. So, upon compulsory retirement, any custodial officer from the rank of correction chief, superintendent, and below shall be entitled to retirement benefits cum com, computed of the basis of one grade higher than the position last held, provided that the retirement pay shall be subject to adjustment based on the prevailing scale of base pay of the uniformed personnel in the active service. So, next slide. So, section 21, funding sources or funding source. The funds required for the implementation of this act, including personnel benefits, shall be taken from the budget of the Bucor for the current fiscal year and also from the following. So, collection from clearance and certification fees, income from institutional projects subjects to memoranda of agreement o MOAs, contracts or joint venture agreements, and other miscellaneous incomes outside MOAs and contracts, such as penal farm, production, and inmate handicraft industry. Thereafter, such amounts as may be necessary to implement this act shall be included in the annual general appropriation act. So, the funding sources of the Bucor is one of them is the penal farm production. So, the inmates have or the programs also involve agricultural. The the employees are the inmates. So the income from that agriculture or in the harvest time, so there are percentage of their income will be in the will give into the institution or the Bucor. So, next slide. So, section 22, implementation. So, the implementation of this act shall be undertaken in strategized phases, but not to exceed exceed 5 years, taking into consideration the financial position of the national government, provided that any partial implementation shall be uniform and proportionate for all ranks. So next is section 23. So implementing rules and regulation, the DOJ in coordination of the with the Bucor, the CSC, the DBM, and the Department of Finance o DOF shall within 90 days from the effectivity of this act promulgate the rules and regulation necessary to implement the provision of this act. The next slide. So section 24, transitory probation. So the incumbent director and two incumbent assistant directors shall serve under the terms for which they have been appointed without need of new appointments upon the enhancement of this act. So all incumbent personnel who upon the effectivity of this act shall opt to early or optionally retire from the service will be entitled to the retirement benefits computed as follows. So the age requirement starts from 57. So age basis for computing benefits starts for of 62. So next slide. So all incumbent personnel upon the effectivity of this act may continue to render services until one reaches the compulsory age of retirement for public officers of 65. Thus who shall be newly hired will be have a compulsory retirement of 56 years pursuant to the prevailing provision of retirement age of those who are in the uniform service. So next slide. So in section 25, so annual report, the Bucor through the DOJ and the DBM shall jointly submit to the President of the Senate and the Speaker of the House of Representatives an annual report of the implementation of this act. This report shall include information of the application of the budget for the salary and other benefits provided under this act. The DBM in consultation with the Bucor through the DOJ shall periodically reviewed and adjust every 5 years the rates of base pay, taking into consideration labor productivity, consumer price index, oil price, and other similar economic indicator as may be determined by the National Economic and Development Authority or NEDA. So next slide. So section 26, separability clause. So in any portion or provision of this act is declared unconstitutionally, the same shall not affect the validity and effectivity of the other provision not affected thereby lawful. So next, section 27. So repealing clause. All laws, decrees, order, rules and regulation and other issuance or parts thereof which are inconsistent with the provision of this act are hereby deemed repealed, amended, or modified accordingly. Effectivity clause. So this act shall take effect 15 days after its complete publication in the official gazette or in at least 2 newspapers of general circulation whichever comes earlier. So next slide. So this act, which is a consolidation. So this act, which is a consolidation of House Bill number 6887 and 6887 and Senate Bill number 3335 was finally passed by the House of Representatives and Senate on February 5, 2013 and February 6, 2013. So next slide. So it is approved in May 24, 2013. So next is Republic Act 592 was enacted in 2013, amending Republic Act 3815 or the revised penal code. The law increased the GCTA of prisoners to be credited in the service of their sentence. Last June, the Supreme Court ruled that the law should apply retroactively. So some lawmakers, including Senate President Vicente Soto III, are calling for a review of the law. But what exactly is GCTA? Can all prisoners benefit from it? So here are 4 things you should know. So next slide. So what is good conduct time allowance? So good conduct time allowance or GCTA is a sentence reduction provision afforded prisoners who show good behavior and has been in existence since 1906. Act 1533 provided for the diminution of sentence imposed upon prisoners in consideration of good conduct and diligence. Citing a citing a 1908 decisions, the EC said the law served a double purpose: to encourage the convict in an effort to reform, so and include habit of industrial and good conduct in the person beyond one sentence, and aid to discipline various jail and penitentiary. So 24 years later, the RPC is a legal code governing crimes and their punishment was signed into law. So incorporating good conduct time allowance for any prisoners in all penal situation. So next slide. So what is RA 10592 and how does it work? So in May 2013, then President Benigno Noynoy Aquino III signed RA 10592, amending Articles 29, 94, 97 to 99 of the RPC, which sought to expand the application of the GCTA to those under preventive imprisonment or those detained prior and during criminal trial who are deemed to dangerous for release. So next is increase the number of days that may be credited for GCTA. So allow an additional sentence deduction of 15 days for each month of study, teaching for mentoring service, and expand the special time allowance for loyalty and make it applicable to those under preventive imprisonment. So next slide. Who can benefit from the law? So Inmates who displayed good behavior and no record of breach of discipline or violation of prison rules and regulations may be eligible for GCTA. According to the Bucor operating manual as cited in the EC decision, the IRR or Republic Act 10592 defines good behavior as the cons- conscientious and satisfactory behavior of a detention or convicted prisoner consisting of active involvement in rehabilitation programs, productive participation in authorized work activities or accomplishment of exemplary deeds coupled with faithful obedience to all prisoners' jail rules and regulations. So next slide. Over the past years, Sanchez was found to have violated jail policies according to reports from Philstar.com, Rappler, and CNN Philippines. So in 2006, a complaint was filed against Sanchez for allegedly pos- poisoning, possessing shabu and marijuana. In 2010, a kilo of shabu worth 1.5 million was discovered in one of the Blessed Virgin Mary's statue inside his cell. 5 years later, and an air conditioner, flat screen television, and refrigerator were seized from his cell. Sanchez also tested positive from illegal drug use according to a Bucor report. So next slide. Who are excluded from the law? Recidivists or those who have been convicted previously twice or more times of any crime, habitual delinquents, escapes, and persons charged with heinous crimes are excluded from its coverage according to Section 1 of RA 10592. The law, as well as RPC, however, does not define what constitute a heinous crime. Under Republic Act 7659 or the Death Penalty Act, heinous crimes are grievous, odious, and hateful offense, and which by reason of their inherent of manifest rig, rigness, viciousness, atrocity, and perversity, and repugnant and outrageous of the common standard and norms of decency and morality in a just, civilized, and ordered society. So next slide. The Death Penalty Act, which was repealed in 2006, classified murder and rape as heinous crimes that may be punishable by death. So in 1995, Sanchez and 6 others were sentenced to 7 terms of reclusion perpetua for the brutal rape and murder of University of the Philippines Los Baños student Eileen Sarmenta, and for the torture and murder of Alan Gomez, another student 2 years prior. Under the RPC, the maximum detention period is 40 years, regardless of number of terms that one must serve. This means Sanchez will serve only 40 years in prison and most, even if he was sentenced to 7 terms of life imprisonment. So next slide. So, in 1996, the court convicted Sanchez and three others of double murder of father and son Nelson and Rickson Piñalosa. Sanchez was already in jail then for the rape slay of Sarmenta and the killing of Gomez, according to the Inquirer.net, Philstar.com, and ABS-CBN News. In 1999, the EC affirmed the lower court's ruling against Sanchez for the Sarmenta Gomez rape slay and the Peñalosa slay cases. So that's all for this video. Thank you for listening. Have a good day.